telah hantar delegasi seramai 9 orang. Cabas saya ucapkan kepada semua dan marilah kita memberikan tepukan gemuruh kepada mereka dan semua yang hadir di persidangan ini. Tun, YB, your presence is testament to the importance of convening this inaugural conference, the first of its kind, to bring together stakeholders from the ministry, developers, judiciary, lawyers, academicians, and all those who share a common interest in local government laws. To this very auditorium, to listen to what industry experts have to say, to gain insights and understand the intricacies of local government laws, to reflect on and discuss current issues, and to put forth impactful, sustainable, and viable solutions for our progressive nation building. The local government, which represents the third tier in the administrative structure, is a multifaceted entity, sensitive at times, but has daily impact on our lives in ways that can either be positive, negative, or even sometimes controversial. Conflicts within this area are experiencing a noticeable surge, as evidenced by the increasing number of cases brought before the courts of law. To date, according to the judgments that we have reported in our CLJ website, there has been approximately 572 cases pertaining to local government matters, 74 from the Court of Appeal, 40 adjudicated by the Federal Court. Interestingly, in the most recent year alone, 59 cases were heard in the courts of Malaysia. And from what I understand, there is actually one already in the Federal Court at the moment. These decisions handed down by the courts often set the path of change for future governance and policies. Thus, we feel it appropriate and timely that today, we bring together this intelligentsia panel of speakers comprising of honorable judges, legal experts, local government officials, academics, members of the Attorney General Chambers, parliamentarians, and individuals from the Property Development and Local Government Ministry, each contributing their wealth of expertise and insights. We believe that sharing experiences and knowledge is the enabler of well-informed and effective decisions. Our hope is that during this two-day conference, our delegates will wholeheartedly embrace the motto of Carpe Diem, to learn, to gain insights, and to ask questions actively in the slotted Q&As. We trust this venue and our event organization will create an uplifting environment conducive for a meaningful and pleasant discourse amongst our fellow delegates. To further enhance the conference experience, we have created an online community group on Facebook called Community National Conference on Local Government Laws 2023. I believe we have the handles being shown there. We strongly encourage all delegates and our invited guests to join and become an active member today, and even after the conclusion of this event. We hope this continued involvement allows you to stay updated with the latest developments, access valuable resources, participate in discussions, and engage with a broader network of like-minded professionals. We will be sharing event photos, latest news, interesting articles, landmark decisions from the courts, and other information relevant and would be of interest to our delegates and speakers. Be sure to also follow us on Instagram, X, and LinkedIn for updates. Bak kata pepatah, all work and no play makes Jack a dull boy. Saya menggalakkan anda semua untuk menikmati segala yang kami tawarkan selama 2 hari ini. Kunjungilah pameran-pameran yang kami sediakan, antaranya CSS Strata Property Management Solution, Bank Islam Malaysia, Life and Financial Planning by ISLA, Marsden Law Book, MyGlaw, dan gerai buku penerbitan dan demonstrasi Digital Solutions oleh CLJ. Cubalah nasib anda di permainan spinning wheel dengan cabutan bertuah. Siapa tahu anda tidak akan pulang dengan tangan kosong. Hadirin hadirat yang dihormati, saya berdoa agar persidangan ini memberikan banyak manfaat kepada para delegasi. Dengan sokongan daripada Tun dan YB Tuan Haji Akmal, saya berharap agar persidangan perdana ini boleh menjadi satu acara tahunan yang mana para delegasi dan penceramah akan gembira untuk mengambil bahagian, insya-Allah. Sekian, wabillahi taufik wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much to Madam Rosina. Although we may return with empty hands, however, surely we will not return with empty minds and empty hearts, for we will be learning lots from today's and tomorrow's conference. Dalam memajukan negara bangsa ke hadapan, sambil memastikan kebolehterusan masyarakat, amatlah penting bagi kita untuk mengamalkan satu budaya yang mampan demi kestabilan terjamin. Perkara ini memerlukan keseimbangan segala bidang dan disiplin secara tertib juga strategik.
The step towards a sustainable future must start small and locally. Thus, local governments are key players in sustainable nation building, bringing direct impact towards communities in urban planning, infrastructure, and policy implementation. Therefore, it is my utmost honor to invite Yang Amat Arif, Tun Tengku Maimun binti Tuan Mat, Chief Justice of Malaysia, to deliver her keynote address. Please welcome.
Honorable Judges, Ms. Karen Chia Yilin, President of the Malaysian Bar, top management of CLJ, mayors, distinguished speakers, distinguished guests, presidents of local authorities, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to all of you. It is both an honor and a privilege of mine to be invited to deliver the keynote address, on the occasion of the National Conference on Local Government Laws 2023. Very often I am invited to attend or speak at conferences which focus mostly on areas such as constitutional law, civil law, criminal law, or even alternative dispute resolution. It is not often that there is a conference on the very important topic of local government. I must commend CLJ Malaysia for their effort of convening this pivotal conference. Local governments are the closest to the people as they play the vital role of educating, mobilizing, and advancing or responding to the public in advancing sustainable development. As such, even if local governments are technically the lowest in the hierarchy of power, they are not any less significant. I therefore take the view that the central theme assigned to my keynote address, that is, local governments and nation building towards sustainability and progress, quite neatly encapsulates the immense significance of the role of local government. In the time that I have, I would like to address three key areas, which are, firstly, the constitutional and legal basis for local government, secondly, the role that local government plays, and thirdly, and perhaps more aligned to my own constitutional functions, the role of the judiciary as relates to the first two areas I just mentioned. The Federal Constitution does not only demarcate between the three major branches of government, to wit, the executive, the legislature, and the judiciary, but it also separates these branches into their various sub-branches. In terms of the executive branch, at the highest is the federal government, followed by the state governments, and then local governments, which all answer mostly to their respective state governments. Then, within local government, there are 4 categories, namely City Council or Majlis Bandaraya or City Hall, Dewan Bandaraya, Municipal Council, Majlis Perbandaran, District Council, Majlis Daerah, and Special or Modified Local Government. Though I have said that local governments are answerable to their state governments, the Federal Constitution does nonetheless enable the federal government to wield considerable influence over the operations of local governments. For instance, Article 76, Clause 4 of the Federal Constitution empowers Parliament to make laws with respect to local governments for the purpose of ensuring uniformity of law and policy among states. In that regard, for the purpose of uniformity, Parliament has enacted various laws. At the Cabinet level, Article 94, Clause 3 of the Federal Constitution empowers the federal government to form a ministry dedicated to local government affairs. Leveraging on this provision, the Ministry of Housing and Local Government was established and entrusted with the crucial responsibility of strategizing, monitoring, and implementing all policies associated with local governments throughout Malaysia. Having addressed the basis for the existence of local governments, what are they intended to do? Local government, among other things, prescribe and monitor health and hygiene standards, sanitation, provide public amenities, and manage the overall well-being of their constituents. They do this mostly by issuing bylaws, a significant power granted to them by the Local Government Act 1976. They also have officers in their employ who enforce these bylaws and any other applicable laws. Another fundamental facet of their role is town planning and development, which is to be balanced with preservation and public comfort. The mantra that resonates at all levels in this regard is sustainable development, a concept which epitomizes the notion of progress without compromising the needs of future generations. The rules that I have outlined are not unique to local governments in Malaysia only. They are applicable to many other countries throughout the ages. Local governments embody ideal of community, and this, in my view, also resonates with many religious teachings, including, of course, sustainable growth. Islam, for instance, emphasizes a holistic approach to urban development. In this context, Surah Ar-Rum, verse 41 of the Quran, conveys a profound message on the interconnectedness of human actions and their consequences. It highlights how corruption manifests on the land and sea due to the actions of humans, leading them to a taste of the repercussions they have wrought. In the realm of urbanization, this verse translates to a call for responsible and thoughtful town planning to prevent environmental degradation and to promote the well-being of present and future generations. A clear example of town planning based on the principles outlined in the Quran is the city of Medina, which was developed by Prophet Muhammad SAW in the 7th century CE. The layout of Medina reflects Islam's emphasis on community and social cohesion. At the heart of the city lies the Prophet's Mosque, which serves as a spiritual and communal focal point. The residential, commercial, and public spaces in Medina are also seamlessly integrated to foster vibrant social interactions and communal ties. Rooted in Islamic values, the town planning of Medina serves as an enduring testament to harmonious and balanced urban development. International frameworks have consistently recognized the crucial significance of sustainable development. In 1992, the United Nations Conference on Environment and Development, also known as the Earth Summit, culminated in the adoption of the landmark Rio Declaration. This declaration sets out 27 core principles that provide a broad framework for harmonizing economic development with environmental preservation. The Earth Summit also established Agenda 21, which is a comprehensive plan of action outlining specific strategies to implement the principles set out in the Rio Declaration. Crucially, Agenda 21 emphasizes the participation of local governments to holistically address social, economic, and environmental needs towards achieving a sustainable future locally and globally. Another crucial aspect of the powers possessed by local government is their wide discretion in town planning and development control. They not only grant planning permissions, but are also permitted to impose any conditions to those plans if deemed necessary. The initial stage of the planning process involves the creation of a structure plan by the state government. This plan outlines the state's strategies and proposals concerning land use, encompassing objectives such as economic growth, socio-economic welfare, and sustainable development. And since public involvement is a large facet of this process, the structure plan is required to be publicized for public feedback. Once the structure plan is officially gazetted, it gains the authority of subsidiary legislation. As a result, any development order that contradicts it is deemed invalid. This ensures that the structure plan, once instituted, serves as the definitive guide for the development of the area. In fact, the law is strict on this, as any modifications to a gazetted plan must also require public participation. Local plans, on the other hand, provide a detailed implementation strategy based on the overarching structure plan, which includes environmental conservation measures. Local planning authorities prepare local plans in alignment with the state's structure plan. Local plans receive an equivalent amount of publicity as structure plans, ensuring that potential stakeholders are informed and can contribute feedback. The law requires that land or building use adhere to the plan. Given their significance, the structure and local plans then form the basis upon which all planning permissions are decided. The foundation of the planning system in our jurisdiction is the general rule that no development can be commenced, undertaken, or carried out without the prior consent of the local planning authority, which is granted in the form of planning permission. Given what I have stated thus far, we can appreciate that local governments in Malaysia carry a heavy duty, as their decisions immediately affect the public for generations to come. Attendance to the wide-ranging power is the responsibility to exercise such powers within permissible legal limits, and whether or not these limits are respected is a question for the judiciary. This brings me to the final aspect of my speech on judicial scrutiny, particularly in respect of local government, and how, in my view, this affects sustainable nation building. Judicial review, which comprises constitutional and administrative judicial review, is a cornerstone of our constitutional framework. It is the main device by which the judiciary performs its constitutional duty to check and balance power, This does not mean that the courts or individual judges are now also town and country planners. What it means is that judicial review empowers our courts to scrutinize the decisions, actions, and policies of local governments, ensuring that they remain within the confines of the law. It is not for judges to exercise these powers for local government, but only to ensure that the exercise of these powers is done correctly and legally. When local governments, just like any other executive arm, exceed their power or violate the rights of citizens, the courts are duty-bound to intervene, nullify unlawful actions, and provide remedies to affected parties. This process is essential for preventing abuse of power, promoting transparency, and holding local governments accountable for their actions. This is of course done based on established principles and judicial precedent. Speaking specifically within the context of local government, in a typical case, the courts are called upon to scrutinize and assess whether a local government's decisions to approve proposed developments fall within the bounds of environmental preservation or generally compliance with legal principles. I would like to refer to two recent decisions of the Federal Court to illustrate my point. Earlier this year, the Federal Court rendered judgment in the Sunrise Garden case. The central issue in this case revolved around the validity of planning permission granted by the local planning authority in Penang in 2012 for the construction of a housing development project on hillside land. Of crucial relevance was the fact that the Penang structure plan contained a general prohibition against development on hill slopes. However, the State Planning Committee, without following the requisite statutory procedure to make alterations to the structure plan, issued a set of guidelines defining the exceptions to the prohibition against hillside development as set out in the structure plan. The disputed planning permission was granted by the local planning authority on the basis that the proposed development fell under one of the exceptions defined in the guidelines. The Federal Court held that the issuance of these guidelines amounted to an alteration of the structure plan in contravention of the relevant provisions of the Town and Country Planning Act 1976, which requires that any such alteration to a gazetted structure plan must go through the process of public participation. And it followed that the State Planning Committee had acted ultra vires its powers under the Town and Country Planning Act 1976 in implementing these guidelines. The Federal Court also noted that the State Planning Committee cannot bypass the mandatory legal requirement of requesting prior advice from the National Physical Planning Council in respect of an application for planning permission that involves development affecting hilltops or hill slopes in an environmentally sensitive area. This is to ensure that it is sustainable development and not any development that is granted planning permission in relation to hill lands. The Federal Court further noted that no local plan was drawn up following the gazetting of the Penang Structure Plan 2020 in 2007, notwithstanding the express requirement under the Town and Country Planning Act 1976 for work on a local plan to commence before or soon after the structure plan for the state comes into effect. In this case, the local planning authority had instead treated the zoning plan as a local plan for the purpose of granting the disputed planning permission. The Federal Court found that the zoning plan was not in any way equivalent in nature, substance, or effect to a local plan required by statute. Unlike the preparation of a local plan, there was no element of public participation in the drafting of the zoning plan. This essentially ousted the public's role in influencing and controlling the development taking place in their area. As such, the local planning authorities' attempt to accord the zoning plan the same status as a local plan was held to be in contravention of the Town and Country Planning Act 1976. In my view, Sunrise Garden is an apt example of a case where the judiciary exercised its powers of review with a view to enforcing legal compliance. The case also highlights the role of structure and local plans which the courts will not allow to be sidestepped. In this regard, the judiciary also re-emphasized the need to adhere to environmental protection measures meticulously outlined in the development plans which echo public sentiment. I think this is especially pertinent when it comes to delicate areas like hillland and steep slopes where the environmental impact can be catastrophic. The second decision, which in my opinion is a landmark development in the law generally and local government specifically, is the judgment of the Federal Court in the Taman Rimba Kiara case, especially insofar as locus standi is concerned. As you well know, locus standi refers to the legal standing or right of an individual or entity to bring a case before the court. In the context of judicial review, it determines whether an individual or entity is qualified to commence proceedings to challenge the legality of a public authority's action, decision, or policy. Historically, Malaysian courts have adopted a narrower and more restrictive approach on the issue of locus standi in judicial review cases, which limit who could bring public interest litigation. In the context of local government law, the ramifications of this are significant given that decisions made in this area of the law affect a wide range of people, albeit in different degrees. In Taman Rimba Kiara, the facts concern the grant of a development order in 2017 by the Datuk Bandar of Kuala Lumpur as the local planning authority of Kuala Lumpur in respect of a proposed development located within a public park known as Taman Rimba Kiara. Taman Rimba Kiara was a public park measuring 25.2 acres located within the Taman Tun Dr. Ismail and Bukit Kiara areas. The Kuala Lumpur Structure Plan 2020, which had come into force in 2004, zoned the area comprising Taman Rimba Kiara as a green open space. However, the Kuala Lumpur Local Plan had gazetted the subject land as mixed development. Based on the local plan, the Datuk Bandar of Kuala Lumpur had granted the disputed development order, and this was done despite the respondents' objections regarding the proposed development. A judicial review application was initiated by the respondents to quash the grants of the development order on the grounds that it contravened the structure plan. One interesting feature of this case is that the respondents in the appeal comprised neighboring residents and property owners, prompting, among other things, an objection against their locus standi to initiate the judicial review. Other issues raised before the Federal Court included whether the structure plan was a legally binding document with which compliance is mandatory, and also whether a planning authority in deciding to issue a development order is under a duty at common law to give any adequate reasons for its decisions to persons objecting to the grants of the development order. On the locus standi point, the Federal Court departed from the majority decision of the then Supreme Court in Lim Kit Siang on the basis that it is no longer good law. The Federal Court instead endorsed the minority view of Abdul Kadir SCJ in Lim Kit Siang, advocating for a broad and flexible approach towards locus standi in judicial review cases. The Federal Court held that it is not necessary for an applicant to establish an infringement of a private law right or the suffering of special damage. Rather, it is sufficient that the applicant is able to demonstrate that he is adversely affected by the subject matter of the judicial review, in that he has a real and genuine interest in the matter. In my respectful view, this is a welcome departure and in line with the spirit of local government laws, which emphasize the need for public involvement. To my mind, public involvement must also entail enhanced public scrutiny. In relation to the issue of non-conformity with the structure plan, the Apex Court held that the development order had significantly departed from the said structure plan. Most pertinently, the land in question had already been designated in the structure plan as a green area or open space for public use, and so the subsequent development order for a mixed development without a requisite change to the structure plan was unlawful. The Federal Court accordingly found the development order to be null and void and quashed the same. This, in my view, is an important aspect of the case, underscoring the importance of structure plans and thereby upholding the purpose of local government laws. In Taman Rimba Kiara, the Federal Court also went a step further by emphasizing the duty of a local planning authority to give reasons for its decision to persons objecting to the grant of planning permission, even though an express requirement to give reasons is absent in the applicable statute. The existence of the duty to give reasons was grounded on the special circumstances of this case, where the grant of planning permission had departed from the structure plan, which the court suggested had created a situation which necessitated the giving of reasons. The law is very clear that local governments must act transparently and openly, which in my view is geared towards sustainable progress. The two recent federal court cases indicate how the judiciary plays its role to ensure that the spirit of the applicable laws is not lost. Insofar as the federal constitution and the law are concerned, the existence of the judiciary and the judicial process serves as a reminder that no power is unfettered. These laws and their requirement of public involvement and detailed processes are targeted at ensuring that we do not just develop, but develop sustainably. There will be times where provisions of the law are stretched, giving rise to litigation. And in such cases, the judiciary plays the important part of checking and balancing such exercise of power. With this assurance, we can collectively continue our journey towards sustainability and progress, knowing that the rule of law underpins our nation's development and future. In closing, I would like to reiterate that local government, particularly in their capacity as local planning authorities, bears the unenviable responsibility of shaping the path of our communities towards sustainable development. I have perused the program brochure, and if anything, the importance of this subject is made apparent by the many important topics to be discussed by the many eminent speakers who are lined up. With that, I thank you for your time and attention and wish you a fruitful conference.
Terima kasih diucapkan kepada Yang Amat Arif Tun Tunku Maimun atas ucap tama yang diberi. As mentioned by Yang Amat Arif Tun, the Quran has, and through our Prophet Muhammad SAW, has highlighted and warned us about the corruption of land and sea, and teaches us about sustainable development for our own to take as an example in our works, be it as town planners, land surveyors, or even legal officers. The two recent federal court cases has also showed the importance of judicial review in ensuring a sustainable future.
Pelaksanaan sesuatu kenyataan memerlukan kerjasama semua pihak. Oleh itu, peranan kerajaan tempatan adalah berasaskan pada kerjasama kerajaan persekutuan, terutamanya Kementerian Pembangunan Kerajaan Tempatan. Dengan itu, dengan segala hormatnya, kami persilakan Yang Berhormat Tuan Haji Akmal Nasrullah bin Muhammad Nasir, Timbalan Menteri Pembangunan Kerajaan Tempatan, bagi menyampaikan ucapan khas.
Terima kasih saudara dan saudari pengurusi majlis. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera. Alhamdulillah. Alhamdulillahirabbil alamin. Wassalatu wassalamu ala asyrafil anbiya'i wal mursalin wa ala alihi wasahbihi ajma'in. Yang Amat Arif Tun Tengku Maimun binti Tuan Mat, Ketua Hakim Negara Malaysia, Yang Berusaha Puan Rostina Gaus, Pengarah Urusan CLJ selaku juga organizer for today's event, Yang Arif Datuk Seri Muhammad Firuz Jafril, Yang Arif hakim-hakim kita, Yang Besar Puan Karen Syak, Presiden Majlis Badan Peguam Negara, Ketua-Ketua Jabatan, Bahagian, Agensi, Ahli-Ahli Majlis Bandaraya, Datuk Bandar, Setiausaha, semualah para peserta yang dapat hadir pada hari ini, yang berhormat Tan Sri Datuk Seri, hadirin sekalian. Pertama sekali saya amat berbesar hati dapat hadir pada hari ini bagi mengikuti Persidangan Kebangsaan Undang-undang Kerajaan Tempatan 2023 mengendalikan cabaran mengekalkan masa depan. Pada masa yang sama, saya ingin mengucapkan ribuan terima kasih kepada Yang Amat Arif Tun Tengku Maimun atas ucapan sebentar tadi. Kalau kita lihat pengurusi majlis tadi gementar, saya lagi gemuruh. Terpaksa berucap selepas Yang Amat Arif. Mungkin next time Yang Amat Arif tak ada siapa boleh berucap selepas beliau lah, sebaiknya. Cuma pada masa yang sama, it's good to be in the conference compared to yesterday's event in Parliament. This is more comforting, lebih selesa, dan saya rasa akan lebih banyak manfaat yang kita dapat ketengahkan pada persidangan 2 hari ini. Dan kalau kita lihat, walaupun itu keadaan di Parlimen, cuma Yang Amat Berhormat Perdana Menteri sebenarnya telah selesai menggulung kajian separuh penggal Rancangan Malaysia ke-12. Dan perkara ini saya rasa seiring juga seperti mana yang telah diungkapkan oleh Yang Amat Arif Tun, berkenaan beberapa perkara melibatkan proses dalam kita menguruskan rancangan di peringkat kerajaan tempatan. Dalam tempoh 2 minggu ini juga sebenarnya saya berkesempatan untuk bersama dalam mesyuarat Majlis Tanah Negara dan juga Majlis Pembangunan Fizikal Negara, seperti mana yang disebut soal pembangunan yang tidak melalui proses, maka perkara itu telah pun diputuskan oleh mahkamah. Cuma Yang Amat Berhormat juga Perdana Menteri memesan ada beberapa perkara yang disampaikan kepada menteri-menteri besar, ketua-ketua menteri selaku mereka yang berkuasa di pihak negeri, dan juga disampaikan kepada peringkat berkuasa tempatan, supaya hasrat dan perkara yang kita cuba capai itu kita selarikan. Buat ketika ini dari segi dasar ataupun pendekatan negara, ada beberapa polisi yang telah kita gariskan dengan agak jelas. Sebagai contoh, bila kita sebut soal sustainable, kita sebut soal kemampanan. Contohnya, kerajaan telah memperkenalkan Pelan Hala 7 Peralihan Tenaga ataupun National Energy Transition Roadmap yang dipanggil NETA. Perkara ini mungkin di peringkat kebangsaan itu telah ditetapkan roadmap, yang mana sebagai contoh kita menyasarkan penggunaan tenaga boleh baharu dan kita tingkatkan daripada 40% untuk 2035, kita tingkatkan sasaran itu 70% untuk tahun 2050. Itu pertama. Yang kedua juga sebagai contoh dasar yang kerajaan angkat pada tahun ini adalah soal Pelan Induk Perindustrian Baharu 2030 ataupun New Industrial Master Plan 2030. Jadi perkara ini, dasar ini juga diangkat bagi memastikan proses urbanisasi, proses pembangunan ekonomi ini lebih menyeluruh dan juga menimbang beberapa perkara supaya kita tidak tergelincir daripada soal sustainability. Itu perkara yang pertama. Jadi bila di peringkat kerajaan, seperti mana Yang Amat Arif Tun terangkan tadi, sungguh pun kita ada perbezaan 3 branches utama dalam negara ini. Dia ada sub branches. Di peringkat kerajaan persekutuan sementara boleh merancang dasar-dasar di peringkat kebangsaan, akhirnya pelaksanaan itu banyak sebenarnya di peringkat negeri mahupun di peringkat kerajaan tempatan. Jadi sebab itu pesanan ataupun hasrat daripada kerajaan persekutuan, sementara kerajaan tempatan terpaksa menguruskan isu-isu harian, sama ada berbentuk aduan, berbentuk permintaan, berbentuk perkara yang kita perlu kuasakan, tetapi juga kerangka yang lebih besar itu kita kena selari. Ini menjurus perkara yang kedua bila kita tengok bahagian soal undang-undang yang disebut tadi daripada sudut pihak kehakiman. Cuma sementara untuk di bawah Kementerian Pembangunan Kerajaan Tempatan, di bawah KPKT ini pun terdapat beberapa akta yang sangat rapat dengan PBT. Contohnya yang sering ditimbulkan adalah masalah pengurusan strata. Isu ini memang sering menjadi pertikaian dan perkara itu kita mungkin dapat uruskan di peringkat tribunal. Dari segi rekodnya yang di bawah tribunal diletakkan di bawah KPKT, saya lihat 2 minggu lepas juga telah berlangsung persidangan Presiden tribunal. Sebelum ini kita ada banyak kes-kes tertunggak di peringkat tribunal. Alhamdulillah, tahun ini kita telah hampir selesaikan kesemua kes yang tertunggak sebelum tahun 2022, yang tinggal hanya ada lagi 5 kes daripada beribu kes yang sebenarnya tertunggak akibat PKP ataupun ketika COVID-19 tempoh hari. Tapi perkara itu tidak bermaksud akta itu kita tidak boleh tambah baik. Maka di peringkat kementerian, sebagai contoh, akta pengurusan strata ini memang dalam penelitian untuk kita lakukan amendment. Perkara yang sama juga soal akta pembangunan perumahan, yang mana memang kalau saya sendiri ketika ini diberi tanggungjawab sebagai pengurusi untuk task force projek perumahan sakit dan terbengkalai. Ini projek-projek yang bermasalah, yang berlaku, dan sudah pasti kehendak semua pemain industri mahukan perkara itu kita tambah baik. Kita nak kurangkan masalah dalam soal pembangunan ini kerana sementara dalam kita merancang pertumbuhan ekonomi, kita ada dasar di peringkat kebangsaan. Kerajaan hanya boleh menetapkan hasrat, undang-undang itu untuk kita mengikat ataupun menetapkan pendekatan yang diambil, tetapi kadang-kala pendekatan itu mungkin ada kelompongan. Kelompongan itu juga mungkin berlaku dinamik yang telah berubah akibat penggunaan teknologi, akibat pendekatan yang berbeza. Jadi amendment itu memang dalam pipeline yang KPKT telah sedang rangkakan. Cuma pada masa yang sama, merujuk kepada akta pembangunan perumahan sebagai contoh, bagi saya tidak cukup hanya kita terus mengatakan akta itu ada kelemahan yang ketara. Kerana bila saya teliti dalam tempoh 8-9 bulan ini, sungguh pun akta itu telah menetapkan beberapa perkara itu tidak berlaku. Contohnya, dalam akta pembangunan perumahan dinyatakan keperluan adanya akaun pembangunan perumahan ataupun ringkasannya HDA. Dalam HDA, dalam section itu saya baca, saya bukan daripada latar belakang guaman, tapi kena faham juga subsection berkaitan dengan HDA sebagai contoh, menetapkan bahawa setiap pemajuan itu perlu ada akaun yang khusus bagi pembangunan perumahan HDA. Tetapi bila kami semak, bila saya minta balik jabatan semak, sepanjang saya tengok projek bermasalah ini, kita telah mengenal pasti ada 12 jenis masalah yang berbeza dalam menguruskan akaun pembangunan perumahan ini. Contohnya, apabila pemajuan itu dibuat, ada pemaju sebagai contoh menggunakan akaun yang sama untuk beberapa jenis pembangunan projek. Sedangkan akta sebut satu projek, satu akaun. pemantauan itu jelas. Tetapi ini tidak berlaku. Tetapi bila diteliti lebih lanjut, bagi saya nak menyalahkan keadaan ataupun mana-mana pihak agak sukar. Kerana pengurusan akaun itu pun melibatkan beberapa pihak yang berlainan. Pihak KPKT boleh bagi lesen pembangunan APDL, memberi kebenaran membuka akaun HDA, tetapi akaun HDA itu dibuka di peringkat bank. Jadi selama ini dari segi siapa yang govern the account di peringkat bank ini yang menimbulkan pertanya-tanya yang masih belum ada jawapan, dan saya telah mengadakan proses libat urus dengan pihak bank. Ada 13 bank yang hadir untuk kami berbincang adakah proses yang digunakan oleh pihak bank soal due diligence dan sebagainya boleh digerak seiring dengan hasrat akta yang kita ada. Selama ini bila kita kemukakan akta, pihak kita hanya tengok apa yang kita boleh buat. Tetapi siapa sebenarnya yang memastikan semua pihak yang berlainan itu bertanggungjawab? Dan ini juga saya faham rintihan di pihak PBT sebagai contoh. Dari segi kita ada one stop center OSC. Yang ditekan itu adalah PBT. Kamu kena luluskan dengan segera. Ini betul, kalau ada wakil PBT itu hasrat semua pihak. Pihak kerajaan mengatakan hasrat tersebut, pihak pemaju berkenaan tersebut, semua pihak mengatakan perkara yang sama. Tetapi pihak PBT terpaksa mengejar semua agensi pihak yang terlibat untuk mematuhi perkara tersebut. Dan perkara ini tidak berlaku seperti yang kita harapkan. Ada pihak yang sebenarnya tidak memberikan kerjasama yang sepenuhnya. Bila kita panggil untuk bagi ulasan, tidak diberikan ataupun tidak dinyatakan komitmen. Sampai masa pemajuan telah berlaku, baru keluar ulasan. Baru ada permintaan tambahan. Baru dan yang akhirnya kena PBT. Dan saya, bila saya turun ke tapak sebagai timbalan menteri, boleh tengok video TikTok pun saya dah buat. Nak tak nak terpaksa. Saya terpaksa tunjukkan transparent dengan keadaan di bawah. Bila peringkat pelaksana ini terpaksa bergelumang memastikan akta, memastikan peraturan yang kita tetapkan ini boleh terlaksana. Tapi hakikatnya banyak ruang yang kita kena tambah baik. Banyak perkara yang kita kena teliti supaya bila dibebankan itu kepada peringkat PBT semata-mata, jangan biarkan mereka itu terkapai-kapai seorang diri. Jadi soal OSC tadi memang kami ada banyak menerima maklum balas dan kita kena tambah baik. Dan akhir sekali, dalam soal kemampanan, soal sustainability ini, bila sebut sustainable ini sebenarnya kalau di peringkat PBT pemahamannya pelbagai juga yang Arif betul. Kalau tengok sustainability itu mungkin soal kewangan yang mereka runsingkan. Sustainability itu soal mengekalkan kawasan itu untuk terpelihara. Antara kekangan kami, PBT akan minta peruntukan dan kami cuba terbaik untuk mendengar permohonan daripada PBT. Tapi ada kes yang mana kita baru siapkan pembinaan tersebut. Contohnya kawasan Taman Rekreasi Awam. Selepas beberapa tahun, perkara itu dia datang balik minta lagi peruntukan untuk selenggara baiki, baik pulih. Dan perkara ini juga memerlukan pemahaman semua pihak. Kadang-kadang memang bukan salah pemantauan. Jujurnya, kesalahan itu mungkin disebabkan natural. Maksudnya, you bina taman itu tepi pantai, guna besi, sampai 3 tahun memang karat habis. Perkara yang praktikal yang kita tak laksana. Tapi ini rencam PBT. Saya sebut dengan hakim-hakim, dengan yang arif semua untuk memahami bahawa sementara kita di atas ni cuba meletakkan akta yang paling baik. Kita cuba gariskan pelaksanaan yang paling tinggi. Tapi di bawah ini mereka terpaksa bergelut, mereka terpaksa melihat berapa ramai. Nak tepuk-tepuk boleh, kalau tak PBT saya tak bagi peruntukan. Ada yang gurau, itu gurauan, jangan pula yang ni. Tetapi ini yang bagi saya ruang untuk pihak PBT nyatakan apa yang berlaku di bawah ini supaya yang bijak pandai, yang panelis kita nanti ini dapat membantu kita mengenali permasalahan yang berlaku di bawah. Kita cari titik pertemuan supaya akhirnya hasrat daripada peringkat sub-branches tadi, kalau peringkat kerajaan, kita ada peringkat kerajaan persekutuan, kerajaan negeri, kerajaan tempatan, dan juga branches dari segi government itu sendiri, kehakiman, eksekutif dan legislatif ini, kerana akhirnya fungsi check and balance ini adalah untuk memperkuatkan kita semua. Fungsi check and balance ini supaya hasrat sustainability itu tercapai. Sustainability itu bukan sekadar pandangan kita yang saya sebut tempoh pagi, tapi sustainability kita as a country. Now we are talking sustainability yang lebih besar. Soal bagaimana untuk kita memastikan dunia ini, muka bumi kita ini akan terus kita dapat nikmati dan akhirnya perturunkan kepada generasi yang seterusnya. Jadi cukup sekadar itu. Sekian, terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Yang Muhammad Ismail. We would like to ask Yang Muhammad to please remain on stage for the next session.
I would like to invite Yang Ahmad Arif Tun Tengku Maimun, accompanied by Madam Rostina Gaus and Mr. Wan Sharif, to the stage for the launching ceremony.
Panjangnya. Mak. Oh, jauh-jauhnya. Oh.
Sekarang telah tibanya saat yang dinanti-nantikan.
Aku jauh sana. Aku jauh-jauh. Yuk, aku jauh-jauh. Allah. Tunjuk gambar tadi lagi elok tadi daripada gambar gelap ni.
Dengan segala hormatnya, kami meminta Yang Amat Arif Tun dan Yang Berhormat Tuan Akmal untuk meletakkan tangan pada platform yang disediakan.
Baik, siapa yang duduk tengah-tengah ni? Saya duduk tengah-tengah ni.
Thank you very much, Yang Amat Arif Tun and Yang Berhormat Tuan Akmal. Ladies and gentlemen,
Hadirin dan hadirat,
welcome to the National Conference on Local Government Laws 2023. Cenderawasih terbang ke pantai, dari istana datang kemari. Cenderamata adabnya disampai, usai nanti bertemulah lagi. And now, Madam Rostina Gaus will be presenting a token of appreciation to Yang Ahmad Arif Tun Tengku Maimun.
And Encik Wan Syarif akan menyampaikan cenderamata kepada Yang Berhormat Tuan Akmal Nasrullah.
Dia slow, tiba-tiba dia terkejut.
We would like to kindly request our respected VVIPs to remain on stage and proceed to the center of the stage in front for a photography session.
Yang Amat Arif Tun dan Yang Berhormat Tuan diminta kekal di pentas bagi sesi seterusnya.
We would like to kindly request our respective VVIPs and VIPs to proceed to the stage for a photograph with our honored guests.
Nama guru ke? Nama guru. Nama guru. Hah? Foto guru-foto. Bicara apa?
Yes, you're our VIPs.
Boleh tak minta naik yang separuh minta naik stage.
Maksudnya separuh di atas?
Separuh di atas.
Ini nampak kosong, sebelah yang atas nampak kosong.
Boleh di atas.
Dah berat sini pula, ini kosong.
Tak balance lah.
Macam tadi sikit macam ni? Tak balance ni? Tadi sikit tadi.
Sini.
2, 4, 5, 2, 4.
Encik, ke sana encik.
Still tak balance.
Okay, tak boleh.
Seorang lagi. One more, seorang.
Yang belakang.
Yang belakang.
Okay, yang belakang tu minta ke sini sikit. Yang belakang, ya, sini
Tun
sikit. Tun bersama. Alright, lagi sikit, Miss. Okay.
Puan tadi sikit, Puan. Balance kan? Okay.
Okay, kan?
Bila
Kita try,
masuk semua tak?
Masuk. Okay, tengok kamera. Okay, 1, 2, 3. Sekejap. Okay, last one. 1, 2, 3. Okay, sekejap.
One more, ready? Yeah, ready? One more, 1, 2, 3.
Okay.
Thank you. You may return to your respective seats for another photography session with our participants.
Respected VVIPs and VIPs, please look at the camera for the next photography session and make sure you smile with a big, big smile. While waiting, you can adjust your hijabs, bagi tutup sikit, kaki bagi ikut, dia akan kemas. Kalau sempat kacap-kacap makeup ke, boleh juga.